OE-0157, N. Shelley M. Joseph.
Okay, Ms. Fabricant.
Good morning. May it please the court. I'm Judith Fabricant, Special Counsel for the Commission on Judicial Conduct. With me is Howard Neff, Executive Director of the Commission on Judicial Conduct. The background of this matter is in the report of the Commission that was submitted in January. As you know, there was a public hearing over the course of 6 days last June, and in October, the hearing officer issued a detailed report of recommended findings and conclusions. And the Commission accepted and adopted the hearing officer's recommended findings and adopted the hearing officer's recommended conclusions with 2 exceptions, which I will address. The Commission adopted the hearing officer's recommended sanction of public reprimand, although the Commission differs from the hearing officer regarding the language of the proposed reprimand. The hearing officer found that the judge did not knowingly participate in allowing the defendant to exit through the rear door of the courthouse to avoid ICE waiting in front. And from that, the hearing officer found that the judge told the truth to the Chief Justice of the District Court and to the Commission and did not commit the most serious violations that were charged. The hearing officer found that the judge did create the appearance of impropriety and bias in violation of Rule 1.2 of the Code by the tone and substance of her discussion with counsel about ICE, and that she compounded that appearance by having part of that discussion off the record. The Commission adopted that finding and conclusion. The hearing officer relied for that conclusion largely on the impression of Assistant District Attorney Juergens, and that impression fully supports that finding. But the finding need not rest on the impression of any one individual. The strongest evidence of the appearance of impropriety and bias is the recorded part of the conversation, which is available to this court both in the audio recording itself and in a transcript, and the transcript appears in the record in a couple of different places, but I would point your attention to Appendix G to the Commission's report at pages 265 to 271. The Commission's disagreement with the hearing officer relates not to factual findings and not to the recommendation of public reprimand, but to 2 recommended conclusions. First, the hearing officer concluded that in going off the record in violation of District Court Rule 211, that the judge did not violate the Code of Judicial Conduct. This was clear error. Rule 1.1 of the Code requires a judge to comply with the law. The Code defines law to include court rules. Violation of District Court Rule 211 was a violation of Rule 1.1 of the Code. The judges—
Is there an intent requirement for that? Because the violation of the underlying District Court rule, the hearing officer found was innocent. So there was no willfulness, no intent, nothing to suggest that. So if that's the fundamental factual basis for the 1.1, wouldn't the 1.1 equally should have some kind of mens rea component to it?
Your Honor, I would say no, not for this kind of violation, and that's because the judge also has a duty under Rule 2.5a of competence. And competence, I would suggest, includes familiarizing herself with the rules of the district court. The judge's ignorance of the rules does not absolve her of the violation, does not mitigate the violation. On the contrary, it's a separate violation. Rule 2.5a requires the judges learn the rules, learn what they need to know, learn the law that they need to know to perform their task competently. And indeed, comment 1 to Rule 2.5 teaches exactly that. Competence requires the legal knowledge that is reasonably necessary to perform the job competently. So I would say that there is no mens rea violation. There is, on the contrary, a requirement that the judge know the rules. And in this regard, we had some discussion at the hearing about the rule book. And the rule book, every judge gets a copy of the rule book. The rule book is very big and fat, and it has thin pages, and it has a lot of thin pages. But the district court rule section of the rule book is this much. It's about 30 pages. And if one were to skim the titles of the rules, one would see that there's a rule about recording. And one might see that rule and read that rule. So I think it is not too much to ask of a judge, of a person, a lawyer who aspires to become a judge, who applies to become a judge and succeeds in that application process, to read the rules of the court that that judge is appointed to. So that's the first disagreement with the hearing officer. The second disagreement with the hearing officer relates to the judge's suggestion to detain the defendant overnight in the absence of any legal basis to do that. The hearing officer treated this as mere error of law, not subject to discipline. And I think this point, this point that the code says that mere error of law is not subject to discipline, and that's where we get the point that not every error of law is a violation of the code, but some of them are. But here, I would suggest that, and it is the commission's view, that this was not mere error of law, not subject to discipline. This was a significant component of the conduct that created the appearance of bias and impropriety. The judge's proposal created the impression that she was willing to use a criminal charge for an illegitimate purpose, to keep the defendant in state custody and away from ICE. These disagreements do not change the commission's agreement with the hearing officer that the outcome should be a public reprimand for creating the appearance of bias and impropriety.
Sorry, I didn't see in the, when I read the transcript, I didn't see the reference I saw in the discussion about detaining the defendant further appeared to be connected to the issue of his identity. It didn't, can you point me to something that in the transcript that would have connected it to an effort or desire to avoid ICE custody?
It's not said explicitly. If you look at the transcript and if you look at the part that begins at 2:48 p.m., and you go through one clip and then go to the next clip, the judge says, and this is the beginning of the sidebar, the judge says, so it's my understanding that ICE is here. So the judge introduces the presence of ICE. And then there's some discussion about the fugitive from justice charge. The assistant district attorney says, I don't think it's him. And then there is a rather long argument by the defense attorney that this isn't the person that ICE is looking for. And the judge says, well, the assistant district attorney says, I don't think ICE is my role. And then the judge says, the other alternative, if you need more time, and pardon me, I want to go back, that discussion by the lawyer about the identity issue with reference to ICE. We're not talking anymore about the identity issue with reference to the fugitive from justice charge. This is identity with reference to ICE. The lawyer says, I think the best thing for us to do is to clear the fugitive issue, release him on a personal, and hope that he can avoid ICE. And then, a few lines down, the judge says, the other alternative, if you need more time to figure this out, is hold until tomorrow. Okay, so far so good. It sounds like an issue of needing time to figure it out. Then we get a couple of more lines. The defense attorney says there's a detainer, and if he's bailed out from Billerica, ICE will pick him up. The judge says, ICE is going to get him, and then the judge says, what if we detain him? That, I suggest, and the commission concluded, you put that together, and that gives you the appearance that the judge is assisting the lawyer in trying to find a way to avoid ICE, and the way that the judge proposes is to detain him in state custody rather than federal custody.
Can I
It doesn't say,
follow up on that,
Can
though?
I just find the page? What you just read is that in the 265 to 271?
yes,
Okay.
yes, and what I'm looking at, the pages, each exhibit within the appendix has its own page numbers, and this is page 5 of that transcript. So I would,
So if I'm looking at your recommended language for reprimand, I take it you're not contending that the without any lawful authority to hold the defendant in state custody, you're not taking on the idea that the judge couldn't have detained her for the purpose of further ascertaining, because the fugitive charge was still pending, right? So you're not taking the position that there was no way to hold the defendant with the pending charge in order to determine if this person was or was not that person, or are you taking that position?
for the Pennsylvania warrant, for
Right.
the fugitive from justice warrant,
Right.
if there were
That
an
would have
issue,
been, that would have been okay.
that would have been okay, subject to the factors that are stated in the statute on the fugitive from justice charge. That statute sets certain requirements. It requires holding if it's a capital offense. Otherwise, it looks to the general factors for bail under Massachusetts law. But the transcript makes it clear that the suggestion to detain him is not to determine whether he's the right person for the fugitive from justice charge. It's about ICE.
Can I follow up on one thing, though? So, but that's the cold read of the transcript or the audio portion of that part. This was also subject to the examination of the hearing officer. And so I guess the part that I struggle with is the hearing officer further inquired about this and concluded something different than some intentional or illegitimate reason for wanting to hold.
Absolutely. And the commission has adopted the hearing officer's finding, the hearing officer's recommended finding, that she did not attend the appearance of impropriety, but she created the appearance of impropriety by the overall discussion, the off-the-record part of it, and this part where she suggests detaining him in the context of a discussion about ICE. It's a matter of appearance, and that is what the commission has found, and that is what the commission recommends a public reprimand for, and it's what the hearing officer recommended.
I guess we get to really where the rubber meets the road. So assuming all of that, that there was a violation of the canons for not being competent, at least as to what the requirements are of the district court rules with going off the record, and this appearance, the cases that we have done public reprimands, although they may not be binding, they're much more harsh than what we have here in terms of proved allegations. Isn't this really, wouldn't this be setting a new bar for actions here that, on the one hand, the first one was found not to be intentional, even though it might still be a violation of the canons, and this one being just the appearance of impropriety?
As we think about the alternatives, if the alternative that the judge has urged is dismissal.
Assume I'm not there. Assume I'm at some lesser sanction that lives between the public reprimand and the dismissal.
So the sanctions between the dissent the dissenter among the members of the commission proposed a private reprimand made public. I think everyone here, and we'll find out whether the judge agrees, but I think everyone here agrees that in light of the public nature of what has happened and the public hearing that has occurred, the public needs to know the result. So whatever happens needs to be public. A private reprimand made public would be awfully confusing to the public. It's been done once before, as far as we've been able to determine, in a situation where there was not a public hearing, but it would be awfully confusing to the public. So I think that's, if there had been nothing in the public and this had been reported to the commission and the commission had conducted its normal process, whether this would be recommended to the court as a public reprimand, I'm not in a position to answer that because it didn't happen that way.
Is there any pragmatic consequence between flowing from, on the one hand, a public reprimand and a private reprimand made public?
I think really just public confusion. The public would look at that and I suggest not understand what that means. I don't think there's a pragmatic consequence to it, except that it would be cited in future cases. I suggest that it would tend to undermine the message that I think this court should issue based on what was done here. And I think there's a very important message that the court should issue. And although I am past my time, I would ask your indulgence to allow me just a short time to state what the commission believes the message should be. And that is that it should have three components. First, a judge must read the rules, must learn the rules, and comply with the rules. A judge has the duty to know the rules of the court that she sits on, to know the law that she's applying, and to learn it if she doesn't know it.
Can I push, before you get to your third one? So what do we do with all of the evidence we have about very experienced judges who go off the record? So this is not the first time in Massachusetts history. The second point I'm much more focused on, but the first one seems to be, are we singling out someone when we know that this is a common occurrence, at least based on the record before us? So that, can you address that before you get to, because the second charge is a totally different ballgame, but the first one seems to be, I mean, I wasn't a trial judge, but based on my reading of the record, this happens a lot.
I would say a couple of things about that, and that goes to the second point, which is that this court should convey the message that every judge must stay on the record in every criminal proceedings. And what I would say about the evidence as to judges going off the record, it was certainly true a long time ago that judges went off the record regularly. There is no doubt that that was true. And the record of the public hearing involved, Judge Joseph said that in her career, she had seen judges go off the record. She also testified that in her orientation as a new judge, that is 4 weeks sitting with other judges in the district court, she never saw another judge go off the record. She was asked, did she ever see a judge go off the record in an arraignment? She first said no, and then she hedged a bit and said, well, it could have happened. She started practicing law in 1993. In 1993, there's no question judges went off the record. We had Judge Ball, who came to the Superior Court in 1996, so she was last in the district court before 1996. She did go off the record in the Superior Court. There's no question about that. She did that before this court changed the rule about lobby conferences. She retired before this court changed the rule about lobby conferences. We had Judge McLeod, who said she did it all the time in the district court. She said she did not do it in criminal cases in the Superior Court because of this court's comments in cases. We had Judge Singleton, who said that he would at least ask the lawyers for a reason, and if he didn't like the reason, he wouldn't do it. He retired in 2014. This event happened in 2018. But I think more significantly, this court has been sending a message since at least 1992 that judges should stay on the record in criminal cases. This court has said it with increasing emphasis over the years. In the Murphy case in 2007, and here I want to respond to something that the judge has said in her opposition. She said that what happened here was not foreseeable. I think the Murphy case teaches that it is absolutely foreseeable that when a judge goes off the record, there will be different versions of what was said off the record. And it's the different versions that brought about what happened here. There would have been no factual dispute, no public hearing. If what the hearing officer found to be the actual facts is true, then there would have been no action by the commission. There would have been, except perhaps as a matter of appearance, if that had been brought to the attention of the commission, there would have been no outcome of the sort that has happened here.
You mentioned that there were three components of, and you were, could you please finish?
Yes.
Say what they are?
The third message that I would ask the court, that the commission would ask the court to send, is that a judge must stay in her role, that the judge must hear and decide matters that are properly before her and not attempt to address matters that are outside her authority. The assistant district attorney said, ICE is not my role. First Justice Heffernan said, I would not get involved. Those were the right answers. Those were the answers the judge should have given, and I think this court should make it clear.
I apologize if I missed number two. Did you separate read and know the rules as two different components?
Read and know the rules, one component. Stay on the record, second component. Stay in the role, third component.
Chief, could you indulge me one question? So the stay on the record is the one that I've got to tell you bothers me the most. I can't speak for Superior Court, but in the community courts, I have a larger philosophical problem, and that's where the judges are constitutional officers, and the idea that there is a district court or Boston Municipal Court rule that tells a judge what they can or can't do in their courtroom when they think it's the appropriate thing to do, I got to tell you, viscerally bothers me. And if that's the index to why it is we say that this is one of the reasons why there ought to be a sanction for this. So are we just conceding that because there's a rule and because Judge Joseph went off, that means that axiomatically that some kind of sanction should flow from that, versus a judge should be able to say, there's some reason why I think I need to go off the record, and notwithstanding there might be a district court rule or BMC rule, that's the judge's prerogative and discretion to do that. We may not like it after the fact. We might look at all the parade of horribles that comes from after the fact, but this happens all the time, every day in community courts.
Two things I would say to that, Justice Georges. First, the SJC approves every rule of every court department. So if the SJC makes a decision that that should not be the rule, then the SJC should direct the district court and the Boston Municipal Court to change that rule. Second, the SJC establishes the Code of Judicial Conduct, including the provision that says that law, as it's used in various places in the code, particularly in Rule 1.1, includes court rules. So if judicial conduct and sanctions for judicial conduct should not address violation of court rules, then this court should change the code.
Thank you.
Thank you.
Thank you. Okay, Attorney Mulvey.
Good afternoon, Your Honors. May it please the court, my name's Elizabeth Mulvey, and I'm here today representing Shelley Richmond Joseph, a judge of the Massachusetts District Court. It's been a long 8-year road for her to get here. In those 8 years, she was indicted by the federal government with, as you can imagine, enormous professional, personal, financial, and emotional consequences. She was pilloried in the press, and she was suspended for a large portion of that time from a job that she was honored and proud to receive. And all of those things happened not because she went off the record, but because of an allegation that turned out to be untrue. Untrue. Now, Judge Joseph has owned from the beginning the fact that she went off the record. And on her behalf this morning, I own that. When she first spoke with Regional Administrative Justice Stacey Fords, who told her about the rule, she admitted she'd gone off the record. She acknowledged she was unaware of the rule, and she agreed that she would never do it again. And she had another meeting with 2 other supervisory judges in the district court, with Judge Forts again and with Chief Justice Dawley. And they didn't treat this as a disciplinary violation. They treated it as an educational opportunity, a new judge who wasn't familiar with the rule, who needed to be educated. And they had a meeting, they discussed it. And you can see from the tenor of the emails exchanged back then in May of 2018, that this was not a disciplinary issue, it was an educational issue. Judges aren't perfect. And honestly, if judges all knew the rules and applied the law correctly, you folks would be out of a job. The reason we have appellate courts is because judges don't always get it right. But I would ask you to think about what has changed since that day in May of 2018, when the district court administration essentially saw this as an educational situation, and today. And what has happened is nothing that Judge Joseph did. What has happened is that the federal government got involved. They got David Jelinek. They gave him complete immunity for his role, and they indicted Judge Joseph. And so I would ask you to do something that is very, very, very difficult, almost inhumanly difficult, and that is to put aside what other people have done, to put aside what has happened since April 2nd of 2018, and to judge Shelley Joseph on what she did and did not do on that day, because that's what she should be responsible for.
So assuming that we begin there,
Yes.
we have these 2 violations that you don't dispute, right? Or let's just say we have 2 violations that were found by the hearing officer and that the board adopted. Not necessarily all of it, but that there was the appearance of impropriety with the detention to seemingly thwart ICE detention, and the first one about going off the record. So we have those 2 violations in front of us. Why should that militate in favor of dismissal versus, I understand the process, I understand how long it was and how arduous it was, how emotional it was, but we still have that before the court. And why doesn't that warrant some sanction?
First of all, the hearing officer didn't find that not knowing the rule and going off the record was a violation. He specifically found otherwise. And I think in light of the evidence in the record, it would be unfair to single her out. In addition to the other judges that testified, and what those of you who were trial judges may remember from your time in the lower courts, let me point to 2 things that are important that happened back then. The first is how this happened. When David Jelinek said, "May we go to sidebar?" the clerk said to him, "Do you want to wait for your client?" Now, if this were going to be anything substantive and case-related, the answer to that would be yes. And his answer was no. So he is approaching sidebar in a situation where he's essentially said, this doesn't have anything to do with my client, or it's not a critical phase, or he doesn't need to be present, whatever. The second is, and if you look carefully at the transcript, how the off the record came about. The defense lawyer said, are we on the record? Judge Joseph said to the clerk, are we on the record, or can we go off the record? He said, what's that? Huh? He wasn't listening. He was doing something else. And Judge Joseph said, are we on the record? And Attorney Jelinek said, can we go off the record? What did the clerk do? The clerk didn't say, Judge, are you sure? Judge, it's against the rule.
Well,
No, wait, can I just finish? Because I am not throwing the clerk under the bus. I am
Sounds like it.
saying that that is an indication of how common this was, that it didn't raise any eyebrows for anybody. It was something that happened. And so to single out Judge Joseph.
I think you're separating. I'm very sympathetic to your point about going off the record generally, but we have to deal with going off the record for this specific conversation. And then we get into Justice Fabricant's point about staying in the role, don't we? So address the harder issue, which is going off the record for this conversation and what was said, because that's what we're going to have to wrestle with. Not the other things are less significant, right?
I understand. And so I would ask you to look at that with not just the finding of an appearance of bias or impropriety, but the word that went before that. And that word is inadvertent. I have not found any case where a judge has ever been disciplined for something inadvertent. And if you look at even the private reprimand cases for appearance.
Again, I just don't want to wooze you without getting the benefit of your thoughts on sort of the
Sure.
most difficult parts of this, which are the hearing officer, which does a very thoughtful, nuanced, credited the ADA when this conversation was, I can't remember the word she used weird and some sketchy, right? Or something, were those the words?
It's something like that.
And it's about ice, weird and sketchy, and off the record. So that's the harder part of this. So I just want to get the benefit of your thoughts on the harder parts.
Sure. I think there are a couple of parts of that. First of all, she was, as everybody agreed, an incredibly credible witness, and it's too bad nobody ever talked to her before going down these roads, because her conduct was completely inconsistent with what happened. She went out to the lobby and said to ICE, he's going to be coming out the front door. So either she's in on it, or she's a moron, or it didn't happen. But let me talk about the word weird and sketchy, because she too was interviewed by the federal government. She had been through this entire 8-year saga. And like anybody else in that situation, she would think about it and look back and think, gee, was it odd? Did something happen? Let's look at what she said and did back that day. She saw David Jelinek coming out of the courtroom with his briefcase with the property bag hanging out. And she said to him, I know what you did, and it wasn't right. And he smiled and walked away. He didn't say, Judge Joseph, you were there. Judge Joseph said it was okay. She stood there with the ICE agent. She didn't call a supervisor. She didn't report to anybody that anything unusual or weird or sketchy had happened. Not that it was her responsibility to do that, but it goes back to my point that people's memories and perceptions are inevitably.
But we're stuck with the findings of the hearing officer.
She testified to that, and she was in a very credible witness.
So we have a situation at sidebar that is talking about something that's not really before the judge. And sorry, go ahead.
I don't want to cut you off, but I do want to push back on that.
Yeah. What is your pushback? Go ahead.
Okay. The pushback is there was a lot going on, and there was a real question of who this person was. The ADA insisted all morning that this fellow was the subject of the Pennsylvania warrant. And in the afternoon, she does a 180 and says, no, he's not. And so it was reasonable for Judge, and here's
It's a fugitive from justice, and then the ADA says, yep, this isn't the fugitive.
Yep.
And then the judge says, well, what if we put him in custody, essentially to keep him away from ICE? That's not her role.
That's not,
So please, answer that.
she wasn't putting him in custody. She started the sentence, if you need more time to figure this out, because the morning had been a series of his previous lawyer saying, I need more time to investigate his identity. And she was making this offer. She wasn't, all she wanted to do, and let me flip it around. Suppose the defense lawyer had said to her, I know I've proven he's not the Pennsylvania guy. I don't think he's the subject of the ICE detainer either, but I need overnight to figure it out. Would you send him to Bill Ricca? Let's come back in the morning and give me a chance to try to convince ICE that they've got the wrong guy. I think it would be entirely appropriate and perhaps inappropriate not to say, sure, we'll hold them overnight. That doesn't obstruct ICE. It gives the lawyer a chance to do his job. And remember, this lawyer had just showed up at 2 o'clock. He was new to the case. It was reasonable for her to think, well, he convinced her it's not the Pennsylvania guy. Maybe he can convince ICE. And it doesn't do anything other than afford the defendant due process to allow time for the lawyer if he wants it. And the lawyer said, no, I don't want the time.
How does that afford the defendant due process if they're being held without any judicial authority?
First of all, I don't think, well,
If the DA says, I don't think this is the person that's the subject of the fugitive, it's not a fugitive charge. That's a capital case. It was an OUI from years before, where presumptively you could have a bail argument on it. But just saying, judges just can't hold people just for the sake of holding people.
she wasn't going to hold him against his will.
But if you say that it would be okay to hold the defendant, to allow the defense lawyer to figure, or the Commonwealth to figure stuff out, how the person's being held without their liberty.
But if his lawyer asks or assents to that, can't she do it?
We don't just sign off on anything
Well,
the lawyers want.
But he's been held all day for the same reason.
Well, there was an open question at that point. When Justice Gaziano fast forwarded, the DA said, I don't think this is the person that's in the fugitive warrant. And so now we're just talking about the ICE detainer.
Right.
Right. So if we're just talking about the ICE detainer and saying, hey, let me give you time to figure out whether or not this is the person that's the subject of the detention order, that's not our role. That's not our role.
In the sense of doing justice, I would like to think that a judge would give a lawyer time to figure out if ICE was going to take the wrong person. And I think to criticize a judge who tried to do that with the best of intentions and to discipline that judge, and this gets to my point.
Before you leave, could you address page 5 that the other side talked about? Could you address that the precise language and how you interpret it differently than they do?
Which,
The language that was read to us earlier. You want to take a shot?
about ICE is going to get him?
I mean, the other side presents this quote from page 5, which is sort of a, sorry.
265?
Yeah. I just would,
I just want to make sure I have the right thing.
it would be helpful to just know your take on that.
Sure. The part that starts, so it's my understanding that ICE is here?
Just what she read to us.
It starts at the sidebar, and she says, so it's my understanding that ICE is here. And remember, she's just spent the whole lunch hour.
Just read to,
Yeah,
just to walk us
Sure.
through.
So stop me, because I'm not exactly sure. So it's my understanding that ICE is here. Attorney Jelinek, inaudible, so there's the fugitive. Judge Joseph, if there's no warrant. ADA Juergens, yes. Attorney Jelinek, there isn't inaudible that we can tie this to him. ADA Jurgens, A, I don't think it's him. Judge Joseph, okay. Attorney Jelinek, ICE is convinced that this is the guy. I went over to ICE, they say they have a biometric match. I went through it and did the research. There's 13 FBI numbers connected to this social. So something's bad with the inaudible. My client denies that it's him. ICE is going to pick him up if he walks out the front door. But I think the best thing for us to do is to clear the fugitive issue, release him on a personal, and hope that he can avoid ICE. ADA Jurgens, I don't think arguing ICE is really my, Attorney Jelinek, right. ADA Jurgens, my Judge Joseph, the other alternative is if you need more time to figure this out, hold till tomorrow.
Okay, that's the key language. So what do you say is permissible about that? I just want to make sure I understand your view. Is it sort of a big picture?
It's a big picture. She's trying to understand. Attorney Jelinek's just told her, I don't think this is the guy ICE is looking for. And he's already just convinced Attorney Jurgens that he's not the Pennsylvania. And she's saying to him, if you need more time to figure this out, this being the ICE issue, she's trying to help. You know, was it the right thing to do?
I thought at one point you were saying that it's okay for a judge to do what she did because of something. And you earlier said something to the effect, it was a little more than just figuring it out, that making sure that ICE doesn't get the wrong, I think you sort of said, making sure ICE doesn't get the wrong person. I'm just asking what you are.
If the lawyer is telling her, I don't think that this is the person ICE is looking for, I want time to figure it out, I would hope as a lawyer that a judge would give me that time. You know, this is.
But there has to be some legal basis, of course, to hold.
What if I, as the lawyer, ask? She didn't do it against his will. She was offering this to the lawyer. Would you like me to do this? And he said no, and she didn't pursue it. I'd like to just move on because I know we've spent a lot of time, and I'm respectful of your time, and talk about the three constituencies to whom your message will be addressed. The first is Judge Joseph, and what you are going to say about what she did that day, her body of work that day, and whether she is going to be disciplined for something that, in essence, no other judge has ever been disciplined. What you say to the public is important because the public, from the time of the indictment, was fed a false narrative. And that narrative, unfortunately, persists today. And that's not fair to Judge Joseph, and it's not fair to the court system. But the most important constituency, I would suggest, because obviously Judge Joseph will be incredibly affected by whatever you do or do not do, but so will every other one of the 400 judges in Massachusetts. Because if there are certainly judges who will say, oh, this would never have happened to me because I wouldn't go off the record. But those who are being honest with themselves will look at this record in its entirety and say, there but for the grace of God go I. Because it's not just the going off the record, it's the use of the word we, it's her tone. And how do you say to judges what rule she violated? How do you dictate tone? How do you dictate the way a judge manages his or her courtroom? And you will be telling judges, especially judges in the district court, whether they can act with compassion, whether they can try to problem solve, or whether they should be guarded in their dealings with lawyers. Because generally when a judge gets disciplined for an appearance of bias, we've all been in the receiving of those. It's sarcastic, it's demeaning, it's nasty. It's not pleasant and trying to help. And so if you discipline her for that, you will be sending a message to every other judge who tries to deal with situations like this. And a district court is a busy place. There isn't time to go research law. There aren't law clerks. There aren't 130 days to make decisions. You're making 20, 40, 80 decisions a day, and they're doing the best they can, and she was doing the best they can. And so if you say to judges, all of whom look up to you, that we are disciplining a judge who was doing the best she can, who didn't do anything willful, who certainly didn't do what she was indicted for, what she was charged with, then you are sending a message that will affect the quality of justice in the Commonwealth. I think the CJC is like any other prosecutor, and the goal shouldn't be to win, it should be to do justice. And to discipline a judge who was trying to do the best she can is just not doing justice, and there's no precedent for it. Thank you.